All right, we are live. Today is February 17th, and we are at the beginning of our series where everybody should start. So if you haven't joined us on our platform for the class, I hope that you do take the opportunity to watch us on YouTube. And today, we are going to go over Private Foundations and Risk Literacy Series, the SS4 and EIN Literacy Handbook Volume 1, Understanding IRS Entity Classifications, EIN Issuance, and Filing Presumptions. Important Notice and Scope and Intended Use. This ebook is part of the Private Foundations and Risk Literacy series. The live YouTube sessions associated with this series are provided for general educational literacy only and are designed to help viewers understand administrative systems, terminology, and common sources of confusion. This ebook goes beyond the scope of the live sessions. It contains structured analysis, sequencing, explanations, and reference material that is not presented publicly and is intended solely for members who have agreed to the Private Membership Association terms. This material does not provide legal advice, tax advice, or instructions for filing. It is designed to support informed decision-making and to reduce harm caused by misunderstanding administrative processes. Private membership use only. Access to this ebook is limited to members of the Private Membership Association who have completed the membership application, agreed to the association agreement, and executed the non-disclosure agreement. Redistributing, excerpting, or using of this material outside the PMA is prohibited. This restriction exists to ensure that the material is studied in its proper context and is not misapplied, misquoted, or used without adequate foundational understanding. The YouTube series teaches literacy. The ebook exists so students don't misapply what they learn. Private Membership Association. This publication is a private educational resource made available exclusively to members of the Private Path HR Solutions Private Membership Association. Access to this material is conditioned upon acceptance of the PMA membership agreement and non-disclosure agreement. Use of this publication is limited to personal educational study by authorized members. Unauthorized members' sharing, reproduction, distribution, or commercial use of this material, whether in whole or in part, constitutes a breach of private contract and may result in remedies available under the PMA agreement, including termination of membership and pursuit of contractual or civil relief where appropriate. Disclaimer and educational notice. This ebook is provided for educational and informational purposes only. It does not constitute legal, tax, or financial advice, and it should not be relied upon as such. The material in this publication is based on private research, historical references, and educational analysis, including concepts taught by Patrick Devine, as interpreted and expanded upon by Private Path HR Solutions. The purpose of this work is to explain administrative classification, presumptions, and common sources of misunderstanding, not to instruct readers on filing compliance avoidance or legal strategy. Readers are solely responsible for their own decisions, actions, filings, and outcomes. No guarantees, express or implied, are made regarding results. For matters requiring professional judgment, readers are encouraged to consult a qualified licensed professional in the appropriate jurisdiction. Copyright and use restrictions. Copyright of 2025 Private Path HR Solutions, PMA, all rights reserved. No part of this publication may be reproduced, stored, transmitted, or distributed in any form or by any means without prior written permission, except for brief quotations used for private study or commentary within the PMA. References to government agencies, including the Internal Revenue Service, are descriptive and educational only. Nothing in this publication instructs or encourages evasion of lawful reporting or compliance obligations. If you would like to contact us, if you have any questions, need guidance, or wish to access additional tools and consulting, visit our website at www.privatepathhrsolutions.com. If you would like to speak with us, send us an email to privatepathhrsolutions@gmail.com. If you wish to join our classes and enjoy the after-class Q&As, for classes, go to classes@privatepathhrsolutions.com. You can also find us on Instagram and TikTok at PrivatePathHR. Final educational clarification. This volume exists to promote discernment before action. It explains how administrative systems interpret information, how misunderstandings arise, and why premature or imitative filings often create unnecessary problems. The material is intentionally restrained to prevent misuse and misapplication. Understanding precedes execution. The purpose of this volume. This ebook exists because the SS4 form is widely misunderstood. Most people believe an EIN creates tax liability. Certain EIN numbers, series, confer special status. Trusts automatically require Form 1041, and filing decisions are triggered by income alone. None of those beliefs are fully accurate. This volume teaches how classification logic works, why certain expectations arise, and how administrative missteps, not wrongdoing, create most compliance problems. Give me one moment. Okay. Who this book is for. This book is required reading for trustees and executors in education, private association members, individuals forming trusts or estates, students exploring private process concepts, and anyone considering applying for an EIN for a non-business entity. This book is not a filing guide. It is a thinking guide. How to read this volume. This volume is not written like most books in the private education space. That is intentional. If you are expecting templates, scripts, step-by-step instructions, fill this box to get this result answers, this book will feel uncomfortable. That discomfort is not confusion, it is misinformation being removed. What this volume is designed to do. This book exists to do three things. Number 1, stop you from copying mistakes. 2, explain why SS4 myths keep collapsing trust structures. And 3, teach you how the IRS actually interprets information, not how the internet claims it does. You will notice that this volume explains what boxes mean, explains what boxes do not do, and repeatedly warns against using the SS4 as a strategy tool. That is deliberate. Why this book does not tell you what to put anywhere. Most people get into trouble with the SS4 because they were taught what to enter, not what the form is actually asking. This book teaches literacy, not execution, interpretation, not tactics, and restraint, not shortcuts. If you finish a chapter and feel like, I understand this better, but I'm not ready to file anything yet, that means the book is working. About the lists you will see. You will see numbered sections and lists throughout this volume. They are not checklists, they are thinking corrections. Each list exists to walk you through what people commonly believe, why that belief feels logical, where it breaks down, and what actually matters instead. You are not meant to memorize these points. You are meant to recognize faulty thinking patterns. What this volume will not do. This volume will not make a trust foreign, prevent Form 1041 by itself, activate an estate, create special status, or override IRS reporting rules. Anyone claiming otherwise is confusing education with execution. Where Patrick Devine's teachings fit, you will see concepts discussed that align with the educational work of Patrick Devine. This volume stays aligned with his emphasis on capacity, restraint, and sequence. It does not teach SS4 manipulation, and it does not convert estate concepts into form tricks. Where confusion exists online, this book clarifies it. Why you may want more education after this volume. This volume is meant to leave you informed but unfinished. If you find yourself thinking, I don't want to mess this up, I need guided discussion, or I want to understand how this applies before I act, that is intentional. Application, discussion, and deeper study happen inside the PMA, not in this book. Final instruction to the reader. Read this volume slowly. Do not rush to action, and do not try to use what you are learning yet. Understanding always comes before execution. Part 1. The IRS Classification Fundamentals. Chapter 1. How the IRS thinks about entities, not how people think. Why this chapter comes first. Before discussing forms, EINs, trusts, or filing expectations, it is essential to address a more fundamental issue. Most people misunderstand how classification works. This misunderstanding leads to a dangerous pattern. Forms are filed before concepts are understood. Assumptions are made based on internet explanations. Legal terms are treated as magical labels rather than functional categories. Chapter 1 exists to reset the reader's perspective. This chapter does not teach how to file anything. It teaches how classification decisions are made and why intent alone does not control outcome. Without this understanding, every subsequent chapter will be misread. How to read this chapter. Most people approach the IRS assuming intent controls outcome. This chapter walks through step by step how that assumption is replaced by classification logic. Each section corrects one layer of misunderstanding. Read them in order. Number 1. The core misalignment. Most conflicts between individuals and the IRS begin the same way. People assume intent determines classification. Specifically, individuals think in terms of intent. The IRS operates in terms of classification. This difference alone explains the majority of disputes surrounding EINs, trusts, and filing expectations. The IRS does not evaluate why you created an entity, whether you consider it private, or whether income was intended. Instead, it evaluates what the entity appears to be, how it is described, and what functions it seems designed to perform. The SS4 is the first place this evaluation occurs. Number 2, the IRS as a classification agency. The IRS is not a registry that approves structures. It is a classification authority tasked with determining what kind of entity exists, whether that entity fits within taxable frameworks, and what reporting regimes might apply. This determination is made before income exists, before accounts are open, and often before any activity occurs. The purpose of classification is not enforcement, it is administrative anticipation. This is why good intentions do not prevent administrative consequences. Number 3, why intent does not control classification. These frameworks are not penalties. They are sorting mechanisms used before any obligation is determined. A common assumption is that intent governs outcome. For example, I didn't intend to earn income. This trust is only administrative, or this EIN is just for record keeping. Intent may matter later, but initial classification does not rely on intent. It relies on the language used, the boxes that were checked, and the categories selected. The SS4 is therefore not a passive form, it is a declarative instrument. How presumptions are formed. Number 4. This section exists because the phrase subchapter J causes unnecessary fear and premature filing. Presumptions arise when an entity fits a known category and that category typically carries reporting obligations. For example, businesses, income reporting is expected. Trusts, subchapter J, is considered. And employers, payroll reporting presumed. Presumption does not equal obligation, but presumption does trigger correspondence, monitoring, and follow-up if activity later appears inconsistent. This is why misunderstandings compound over time. An expanded section number 4, how presumptions are formed and why subchapter J is considered matters. What a presumption is and is not. A presumption is an administrative expectation, not a legal verdict. When the IRS encounters an entity that fits a familiar category, it does not immediately impose liability. Instead, it anticipates that certain reporting frameworks may apply if qualifying activity occurs. This anticipation is what most students mistakenly interpret as an automatic obligation. The presumption does not equal a requirement. Presumption is not guilt, and presumption is not enforcement. Presumption simply means if this entity functions as expected, this reporting framework would normally apply. Part 2 of that expanded section is why trust triggers subchapter J review. Under the Internal Revenue Code, most trusts fall under subchapter J, which governs trust income, deductions, distributions, and fiduciary reporting. When an entity is identified as a trust, subchapter J is considered, not automatically applied. This distinction is critical. Considered means the IRS evaluates whether the trust fits taxable trust frameworks. Filing expectations are tentatively associated, not imposed. And further facts, like activity, income, or distributions, are required before obligations exist. Most people never learn this distinction. Whether a Form 1041 filing obligation exists depends on the presence of taxable income or other statutory triggers. Number 3, the common misunderstanding. A widespread belief is if a trust exists, it must file Form 1041. This is incorrect. The correct framework is: number 1, a trust is identified. 2, subchapter J is reviewed as a possible framework. And 3, filing obligation arises only if qualifying conditions are met. However, because subchapter J is the default analytical lens for trusts, students experience it as automatic, even when it is not. This is how confusion begins. Number 4, why subchapter J considered is not a threat. The phrase subchapter J considered should not be alarming. It does not mean the trust is taxable, income exists, or a return is immediately due. It means the trust is being evaluated under the correct statutory lens. The IRS is prepared to apply those rules if activity warrants it. In other words, classification precedes obligations. And Part 5, why administrative and estate trusts are often misclassified. Administrative and estate-based trusts are frequently misunderstood because they may exist without income, may hold assets without distributing them, and may operate purely in fiduciary record-keeping capacity. However, because the IRS does not evaluate intent, these trusts are often initially associated with subchapter J simply because they're trusts, or trusts commonly fall under that subchapter. Only later does activity or lack of activity clarify whether filing is required. This is why literacy matters more than speed. Our caveat: subchapter J is a framework, not a mandate. Important educational clarification: subchapter J is not a filing command. It is a statutory framework used to analyze trusts when income, deductions, or distributions exist. A trust may exist without income. It may also exist without distributions or exist without public-facing activity. In those circumstances, subchapter J may be reviewed, but Form 1041 may not be required. Many people confuse being subject to a framework with having an obligation under that framework. This confusion leads to unnecessary filing and unintended consequences. And Part 6, why this distinction is rarely explained online. Most online explanations fail here because they conflate trust existence with trust taxation. They oversimplify to avoid nuance, and they treat all trust as operating entities. This book corrects that error. Why this matter for trusts and estates? Now that classification logic is clear, this is where trusts become especially vulnerable to misinterpretation. Trusts are among the most misunderstood entities because they can exist without income. They can be administrative only. They can hold assets without distributing them, and they can exist purely for fiduciary control. However, the IRS defaults to familiar trust categories unless the SS4 and subsequent activity indicate otherwise. This is not malicious, it is systemic. And part 6 of chapter 1, the cost of misclassification. Misclassification can result in unnecessary filing expectations, CP notices, requests for forms that may not be required, and student panic and reactive filings. Also, loss of benefits or standing due to over-reporting. Almost all of these outcomes are preventable through literacy. Most of these consequences occur not because someone did something wrong, but because they acted too quickly. In closing of chapter 1, why discernment must come before forms. Chapter 1 establishes a single foundational truth. Classification logic operates independently of intent. The SS4 does not ask what you believe. It records what you declare. The IRS does not begin with enforcement. It begins with categorization. Understanding this distinction prevents unnecessary fear, prevents unnecessary filings, and prevents irreversible mistakes. Most importantly, it restores agency through knowledge, not reaction. Understanding this distinction is the foundation for everything that follows, but it is not yet application. Chapter 2. What an EIN is and what it is not. Why EIN literacy must come before any filing. Few misunderstandings cause more long-term damage than confusion surrounding the employer identification number. The EIN is commonly misunderstood as the following: a tax account, a declaration of income, proof of business activity, or evidence of public jurisdiction. None of these descriptions reflect what the EIN actually does. This chapter exists to explain what an EIN actually represents, why it is issued, and why the number itself carries far less meaning than most people assume. Before studying the SS4 line by line, the reader must understand the limited and specific functions of an EIN. How to read this chapter? Most people treat the EIN as proof of something. This chapter explains why an EIN is not proof of income, business activity, jurisdiction, or approval, and why misunderstanding this single point causes years of unnecessary filings. Number 1, the purpose of an EIN. An EIN is an administrative identifier issued by the IRS for record-keeping purposes. Its primary purpose is to distinguish one entity record from another, allow government systems to associate correspondence and filings, and index entity activity when reportable events occur. An EIN is not a license to operate, a declaration of taxable activity, a confirmation of legal status, or an approval of structure. It is best understood as a tracking number, not a determination. It does not determine whether income exists. It only identifies where income would be reported if it does. Part 2. Why EINs exist for non-business entities. The word employer in EIN is historical, not functional. Despite the name employer identification number does not mean that the entity has employees, or that the entity is a business, or payroll exists. EINs are issued to trusts, estates, nonprofits, associations, and governmental units. The common feature is administrative distinction, not commerce. This is why trusts can hold EINs without income, estates can hold EINs without operations, and associations can hold EINs without profit motive. Administrative distinction, not commerce, is the common thread. Number 3, the EIN does not exist to create tax liability. This point cannot be overstated. An EIN does not create income, it does not create tax liability, and it does not convert a private arrangement into a taxable event. Tax liability arises only when there's a taxable income exists, and a taxable entity receives or is deemed to receive that income. The EIN merely identifies where such information would be reported if it exists. This is why receiving an EIN does not create a filing obligation by itself. Number 4, why EIN issuance is not approval. EIN issuance is automated. It is not discretionary. A common misconception is that the IRS approves an entity when it issues an EIN. This is incorrect. The IRS does not review governing instruments, validate trust language, or assess legal sufficiency, or confirm tax posture. EIN issuance means only a record has been created in our system. This is why invalid entities can still have EINs. Poorly drafted trusts can still receive EINs, and non-operational entities can still be indexed. Approval is not part of the EIN process. Validity and obligations are assessed later based on your activity, not at issuance. Part number 5. Why EIN number series are misunderstood. Many online explanations assign meaning to EIN number ranges, suggesting that certain prefixes confer exemption. Certain series indicate special trust status, and certain numbers prevent filing obligations. In reality, EIN numbers are issued sequentially. Prefixes reflect internal routing and processing, and the number itself carries no legal authority. Two entities with identical structure but different EIN prefixes are treated the same if their activity is the same. The number does not control classification. Function and activity do. Part number 6, why EINs are confused with accounts. Another widespread error is treating an EIN as a financial account, a deposit number, or a treasury interface. An EIN is not an account. It does not hold funds, accumulate balances, or represent credits. Any system that claims otherwise is conflating identifiers with financial instruments. Number 7, how EINs interact with filing expectations. An EIN becomes relevant to filing only when a form requires an identifier and a reportable event has occurred. Examples include income reporting, withholding, employment, or certain informational filings. Absent those events, the EIN remains dormant. This is why many trusts hold EINs for years without filing, because no statutory filing threshold has been met. Important literacy reminder: many invalid or poorly designed entities still hold EINs. The EIN does not cure defects, correct structure, or confer protection. It only creates a record. In closing, why the EIN is a mirror, not a trigger. An EIN reflects activity. It does not cause it. When problems arise, they do not originate from the number itself, but from the entity is described, how it functions, and what is reported using that identifier. Understanding this distinction prevents panic filings, over-reporting, or unnecessary exposure. The EIN is not dangerous. Misunderstanding it is. Before studying the SS4 itself, this distinction must be fully understood. Chapter 3. Why EIN number series are misunderstood. How number patterns became myths. Among the most entrenched misconceptions surrounding EINs is the belief that the digits themselves carry legal meaning. Students are frequently told that certain EIN prefixes are special, certain series indicate exemption, and certain numbers signal private, foreign, or estate status. Certain EINs prevent filing requirements. These claims are rarely supported by statute, regulation, or IRS procedure. They arise from pattern recognition without context, reinforced by repetition rather than evidence. This chapter exists to dismantle that confusion. How to read this chapter? This chapter corrects the most common assumptions people bring into the SS4 process. Each section replaces one belief with how administrative classification actually works. Read in order. Number 1. What an EIN number series actually is. Many people believe the EIN number ranges determine jurisdiction or status. Historically, the first 2 digits of an EIN were associated with processing campuses, geographic routing, or internal workload distribution. These prefixes were administrative conveniences, not classifications. Over time, geographic significance diminished, processing became centralized, and routing logic changed. What did not change is the core rule. The EIN number itself does not control classification. Usage does. What EIN prefixes do not represent? Foreign is an IRS classification outcome, not a declaration. It is critical to state clearly that what EIN prefixes do not do. They do not establish jurisdiction, confer exemption, define trust type, override filing requirements, or indicate private or public status, or create or remove tax liability. No statute, regulation, or IRS manual assigns legal authority to the number series itself. Any explanation claiming otherwise is extrapolation or extrapolation, not law. Declaring foreign status without qualifying activities creates contradictions, not protections. Number 3, where the special EIN belief came from. Status is inferred through conduct and records, not proclaimed through language. The belief in special EIN series typically arises from a combination of factors. Number 1, historical coincidence. Certain entity types were once processed through certain centers more frequently. Number 2, correlation mistaken for causation. Similar entities received similar prefixes during certain time periods. Number 3, anecdotal reporting. Individuals compared numbers without understanding back-end systems. And number 4, internet amplification. Claims were repeated without primary source verification. Over time, speculation hardened into rules despite no legal basis. Assertions without matching activity often collapse otherwise sound structures. Number 4. Why the IRS does not classify by number. Names describe entities. They do not transform them. The IRS classifies entities using declared entity type, stated purpose, functional activity, and reporting behavior. None of these are encoded in the EIN digits. Two trusts with identical structure, identical activity, and identical reporting behavior will be treated the same even if their EINs differ. Classification follows substance, not sequence. Naming errors usually compound misclassification rather than prevent it. Number 5. The specific myth of the 98 series EIN. One of the most common claims encountered is that the 98 series EIN is a foreign by default, is estate protected, is exempt from filing, and operates outside IRS jurisdiction. None of these claims are inherently true. A 98 prefixed EIN simply reflects how the application was processed, when and where it was entered into the system. It does not change the underlying classification, override statutory obligations, prevent subchapter analysis, or replace activity-based review. Believing otherwise places undue reliance on a number rather than on lawful structure and conduct. These myths persist because they promise certainty where discipline is required. Number 6. Why this myth is so persistent. The special EIN narrative persists because it offers a sense of certainty, a shortcut through complexity, or a numerical symbol of safety. However, complexity cannot be bypassed by digits. When problems arise, they do not arise because the wrong EIN was issued. They arise because the entity functioned in a reportable manner. Activity contradicted assumed status, and filings or third-party reports occurred. The number never caused the issue. The behavior did. Number 7. The risk of over-reliance on EIN prefixes. Over-reliance on EIN number series lead to false confidence, improper filings, inconsistent reporting, incorrect advice to others, and unnecessary exposure. It also distracts from what actually matters: the purpose, structure, activity, and sequence. Students who focus on numbers instead of the fundamentals are the most likely to encounter problems later. Literacy caveat. Most failures at this stage occur not from bad intent, but from premature certainty. The SS4 records information. It does not grant status, jurisdiction, or immunity. The EIN number series, the 98 EIN, and the Patrick Devine theory. Because many readers encounter discussions of EIN number series through the work of Patrick Devine, it is essential to clarify what his theory does and does not assert, and where misunderstandings commonly arise. What Patrick Devine was addressing. Patrick Devine's discussions around EINs were not focused on the digits themselves as a source of legal authority or exemption. Rather, his work emphasized capacity as the executor, trustee, fiduciary versus the debtor. It also emphasized sequence, the estate first, administration second, and activity last. Jurisdictional posture was private administration versus public commerce, and function over form. In this context, references to certain EIN outcomes were descriptive of how applications were processed, not assertions that the number series itself created protection. Where students commonly misapply the theory. Over time, many students and third-party educators reduced a conceptual framework into a numerical shortcut, incorrectly concluding that a 98 EIN is inherently foreign. A 98 EIN prevents Form 1041 filing. A 98 EIN overrides trust classification, or the EIN prefix itself establishes private status. These conclusions are not supported by Patrick Devine's core teachings, nor by statute or IRS procedure. The error occurs when outcome is confused with cause. Correlation is treated as jurisdiction, and numbers are treated as status. Patrick Devine's work emphasized how one enters a system, not the digits assigned afterwards. Critical clarification for readers. It is accurate to say that certain EIN applications historically resulted in certain prefixes. Those prefixes reflected processing context, not legal immunity. It is not accurate to say that the EIN prefix itself creates protection, the number series controls filing obligations, or the digits override activity-based review. Any private process that relies on the number alone without regard to actual trust activity, reporting behavior, or public-facing transactions is incomplete and exposes the student to unnecessary risk. Closing Chapter 2, Why Substance Always Overrides Sequence. EIN numbers are identifiers, not shields. They do not protect, exempt, transform, or override. They simply label a record. True protection comes from proper understanding, correct classification, and disciplined activity, informed decision-making. The sooner students release the belief that numbers create status, the sooner they can engage with the process responsibly. Understanding these distinctions is essential before examining the SS4 line by line. Part 2, the SS4 as a classification instrument. Oh, I'm sorry, that was Chapter 3. Chapter 4, the SS4 form, purpose, scope, and limits. How to use this chapter? Think of the SS4 as an intake form that creates an administrative file. Each section below corrects one common misunderstanding. Read in order. Why the SS4 deserves its own chapter. Most people approach the SS4 as if it were a simple application. Fill in the blanks, receive an EIN, and move on. This assumption is the source of widespread confusion. The SS4 is not designed to evaluate intent, validate structure, or determine compliance obligations. It is designed to classify an entity for administrative anticipation within the systems of the Internal Revenue Service. This chapter explains what the SS4 is meant to do, what it is not meant to do, and why misunderstanding its scope leads to cascading errors later. Number 1, what the SS4 is designed to do. Most people think the SS4 is a permission slip. It is not. It is an administrative intake tool. The SS4 is designed to collect administrative information so the IRS can create and maintain a record for an entity. To create an entity record, to associate that record with a responsible party, and to anticipate which reporting frameworks might apply if qualifying activity occurs. It is a front-end classification tool. The form captures entity type, stated purpose, apparent function, and administrative expectations. From these inputs, the IRS determines how to index the entity, not how to judge it. It is not designed to grant approval, validate structure, or determine filing outcomes. The key point: the SS4 opens a record. It does not validate your structure or your intent. Number 2, what the SS4 is not designed to do. This matters because students often treat the SS4 like a review process when it is not one. Many misunderstandings arise because people expect the SS4 to do work it was never designed to do. The SS4 does not review trust instruments, assess legality of a structure, confirm tax status, determine filing obligation conclusively, or override statutes or regulations. The form does not ask for governing documents, asset lists, income projections, or distribution plans. This omission is intentional. The SS4 operates on classification signals, not proof. Key point: because the SS4 doesn't review documents, it cannot bless your paperwork, so copying someone else's SS4 answers is a structural mistake. Number 3, why the SS4 functions as a declarative instrument. The SS4 functions as a declarative instrument only in the administrative sense. It records what the applicant claims about an entity at a point in time. It does not adjudicate whether those claims are correct. Declarative here means administratively descriptive, not magic, and not status creating. Every response on the SS4 is a declaration about how an entity appears to function. Examples include whether the entity appears commercial or administrative, whether it appears ongoing or temporary, whether it appears to employ others, or whether it appears likely to generate reportable activity. A declaration on the SS4 becomes relevant only if later activity, filings, or records rely on it. The form, therefore, does not simply collect information. It creates an administrative posture. That posture is simply how the IRS system expects the entity to behave if activity occurs. This is why careless answers can create expectations that were never intended. Because of this, inaccurate or premature declarations do not create protection. They create contradictions. Key point: a careless declaration doesn't create protection, it creates expectations you may spend months correcting. Number 4, classification versus determination. If you only remember one concept from this chapter, make it this: classification is not the same as determination. A critical distinction must be made between classification and determination. A classification is provisional and anticipatory. Determination occurs only after facts exist. The SS4 performs classification. Determination of obligation occurs later based on actual activity, reported transactions, third-party filings, and use of the EIN in public systems. Confusing these two stages is one of the most common errors students make. Key point: Most panic filings happen because people treat an early classification signal as if it were a final ruling. Number 5. Why the SS4 creates presumptions without creating obligations. The IRS uses presumptions for scale, so the system is ready if reportable activity happens later. Because the IRS must manage millions of entities, it uses presumptions to anticipate what may be required later. For example, an entity described as a business is presumed to generate income. An entity described as an employer is presumed to issue payroll. An entity described as a trust is reviewed under trust frameworks. These presumptions enable a system readiness, do not impose liability, and do not mandate filings by themselves. The SS4 creates expectations, not commands. The key point here is that presumption does not equal obligation, but presumptions can still trigger letters, notices, or follow-up questions. Number 6, the limits of the SS4. This section exists to stop two extremes: treating the SS4 like a weapon or treating it like it doesn't matter. The SS4 cannot convert non-income into income, transform private arrangements into public commerce, or create filing obligations where none exist by law. However, it can trigger correspondence, invite follow-up questions, and place an entity on a monitoring path. Understanding these limits allows students to interpret IRS communications calmly and accurately. The key point here is that the SS4 doesn't create law, but it can create attention if the story you tell on the form conflicts with later reality. Number 7. Why errors at the SS4 stage cascade. Most cascading errors begin with one moment. People answer boxes based on internet claims instead of the entity's real function. Errors at the SS4 stage tend to cascade because early assumptions go unchallenged. Later activity is interpreted through that lens, and students react defensively instead of analytically. This is why many people file unnecessary returns, attempt corrective filings too late, and create contradictions in records. Literacy at this stage prevents downstream correction attempts. Key point: the goal is not to fix the IRS. The goal is to avoid creating contradictions in your own administrative record. In closing of Chapter 4, this volume is literacy, not execution. Deeper application and scenario-based trainings belong inside the PMA. Why the SS4 must be understood before it is used. The SS4 is neither dangerous nor benign. It is powerful only to the extent that it is misunderstood. When properly understood, it becomes a neutral administrative step. It does not dictate outcomes, and it does not override substance. When misunderstood, it becomes a source of fear. It invites overcompliance, and it anchors false assumptions. Discernment here protects everything that follows. Chapter 5. How SS4 answers create presumptions. Why no single box controls the outcome. One of the most persistent errors students make when reviewing the SS4 is searching for the one dangerous box, the single answer that supposedly triggers filing obligations or collapses a private structure. That box does not exist. The SS4 does not operate on isolated answers. It operates on patterns. This chapter explains how combinations of answers taken together create administrative presumptions within the systems of the Internal Revenue Service. Understanding this pattern-based logic is essential before examining individual lines in detail. Presumptions are pattern-based, not line-based. Many students believe a single SS4 answer determines everything. It does not. The IRS does not evaluate SS4 responses in isolation. Instead, it asks, does this entity appear designed to generate income? Does it appear ongoing or temporary? Does it appear to employ or pay others? And does it appear likely to interact with public reporting systems? These questions are answered by clusters of responses, not single entries. This is why two SS4 forms with one identical answer can result in a very different expectation. Key point, no single line creates a presumption. Patterns do. The concept of administrative narrative. The IRS does not read intent. It reads consistency across records. Every completed SS4 tells a story. That story may suggest a business commencing operations, an estate in settlement, a trust engaged in administration, an association preparing for activity. The IRS reads the SS4 as an administrative narrative, constructed unintentionally by the applicant. Most problems arise when the narrative contradicts the filer's intent. The filer does not realize a narrative is being formed at all. Literacy means learning to recognize the narrative before it is created. Key point, once a narrative forms, later filings are interpreted through it. How entity type and purpose combine. Entity type answers the question, what is this? Purpose answer, why does it exist? Two of the most influential narrative components are entity type and reason for applying. Individually, these answers are ambiguous. Together, they suggest function. For example, an entity described as a trust and created for ongoing activity. An entity described as an estate and expected to operate indefinitely. Or an entity described as administrative and indicating commercial behavior. These combinations do not create obligations, but they do create expectations. Key point, mismatched type and purpose create early narrative friction. Number 4, how time-based answers shape assumptions. Time-based answers help the IRS place an entity on a timeline, not determine its origin. Several SS4 entries relate to time, like the date entity began, the accounting year, and expected duration. Time-based answers signal whether an entity appears temporary or perpetual, transactional or operational, settling or producing. Entities that appear perpetual and cyclical are more likely to be associated with annual reporting frameworks. This is a presumption of likelihood, not certainty. The key point here is dates influence expectations. They do not retroactively change legal reality. This distinction is addressed in the SS4 line-by-line analysis later in this volume. Number 5, employment and payment signals. Employment questions exist to prepare the IRS for possible wage reporting, not to accuse activity. Another powerful narrative cluster involves employment expectations, payroll declarations, and anticipated information reporting. Even when no employees exist, indicating that such activity is expected can shift an entity into an employer posture, invite monitoring for payroll forms, and associate the EIN with routine filings. This does not impose immediate liability, but it widens the scope of presumed interaction with public systems. The key point is that signals prepare systems. They do not confirm behavior. Number 6, why trusts are especially sensitive to pattern formation. Trusts receive closer scrutiny because they often mix administration, assets, and authority. Trusts are uniquely sensitive to narrative interpretation because they can exist with or without income, operate privately or publicly, and hold assets passively or transact actively. As a result, small signals carry more weight. A trust described as ongoing, administratively active, paying parties, or distributing value will be tentatively associated with trust reporting frameworks, even if no income exists yet. This is not punitive, it is anticipatory. Key point, sensitivity is not suspicion, it is complexity management. Number 7, why presumptions are often mistaken for orders. Most panic responses occur when presumptions are mistaken for instructions. Many students interpret subsequent IRS correspondence as proof that a filing is required, a mistake has been made, or non-compliance has occurred. In reality, most correspondence at this stage reflects presumed applicability. System prompts, automated follow-ups. The IRS often does not yet know whether an obligation exists. It is asking, not accusing. The key point here is a presumption invites clarification. It does not compel action by itself. Number 8, the role of third-party reporting. The IRS often learns about activity indirectly, not from your filings. Presumptions created by the SS4 gain strength when banks, employers, payers, or agencies use the EIN in their own filings. At that point, the narrative is no longer hypothetical. This is why early literacy matters more than later correction. The key point is that third-party data reinforces narratives already forming. It rarely creates them alone. Sorry, I've been up since 4 o'clock, you guys. Please forgive me. Copying an SS4 application. Caveat. Why it signifies and why it is risky. What it signifies. Copying an SS4 usually signals that the filer does not understand the narrative they are adopting. A recurring issue encountered among students is the practice of copying an SS4 application. Whether taken from a Patrick Devine example, an online template, a mentor's file, or a peer's submission, under the belief that identical answers will produce identical outcomes, this belief is misplaced. What copying an SS4 actually does. When a student copies an SS4, they are not copying a neutral form. They are replicating an administrative narrative that was created for a different entity at a different time under different circumstances. By copying an SS4, the student is declaring, often unintentionally, that their entity has the same purpose. Their entity anticipates the same activity. Their entity has the same administrative posture, or their entity fits the same presumptive frameworks. This may or may not be true. The SS4 does not validate whether the narrative is accurate, it records it. The key point here is when you copy an SS4, you inherit assumptions you may not be able to sustain. Why Patrick Devine's examples are commonly misapplied. Patrick Devine's SS4 examples were never intended to be universal templates, guaranteed outcomes, or copy and paste solutions. They were context-specific illustrations tied to a particular capacity, a particular sequence, a particular administrative posture, and a particular educational framework. When those examples are copied without understanding the underlying assumptions, students often recreate the appearance of a structure without the substance that made it coherent. The result is confusion, not protection. Why outcomes cannot be reverse engineered. Many students attempt to reverse engineer an outcome. This EIN worked for someone else. This SS4 produced a certain prefix, or this application avoided correspondence. This approach misunderstands how classification works. Outcomes are influenced by the totality of answers, the timing of submission, and the subsequent activity. Third-party reporting changes in IRS processing over time. Two identical SS4s submitted in different years can yield different administrative handling. Copying does not preserve context. What copying an SS4 signals to the system, from an administrative perspective, copying an SS4 signals only one thing. This entity asserts the same characteristics as the example it copied. If that assertion later conflicts with actual behavior, activity, or reporting, the system responds to the conflict, not the copied form. This is why copied applications often lead to unexpected correspondence, requests for clarification, pressure to file forms that were never anticipated. The problem is not the SS4 was copied. The problem is that the copied narrative does not match the reality. Educational clarification for students. This volume does not discourage learning from examples. It discourages substituting imitation for understanding. An SS4 must reflect the entity that actually exists, the activity that is actually anticipated, and the administrative posture that will actually be maintained. Anything else creates fiction later. Key principle to remember: you cannot inherit administrative posture by copying paperwork. Posture is established by understanding, sequence, and conduct. Patrick Devine's work emphasized capacity and restraint, not mechanical duplication. This caveat exists to preserve that principle. In closing, why patterns matter more than answers. The SS4 does not trap applicants with a single checkbox. It builds an administrative picture from patterns of information. Understanding this allows students to read IRS correspondence accurately, avoid panic-driven filings, and recognize when expectations are provisional. Distinguish inquiry from obligation. Most SS4 problems are not caused by bad answers. They are caused by unexamined combinations. This chapter explains how expectations form, not how to respond to them. Response strategy belongs later after posture and capacity are fully understood. Chapter 6, Administrative EINs versus Reporting EINs. How to read this chapter. This chapter explains how an EIN moves from being dormant to being reportable. Each section describes a function change, not a filing choice. Read this chapter as a progression, not a checklist. Why some EINs stay quiet and others do not. One of the most confusing experiences for students is discovering that two entities can both hold EINs, sometimes for years, yet only one becomes associated with filing notices, correspondence, or reporting expectations. This discrepancy often leads to incorrect conclusions: that the EIN number itself is responsible, or that a special filing was triggered unknowingly, or that a mistake must have been made. In reality, the distinction is not found in the EIN itself, but in how the EIN is used. This chapter explains the functional difference between administrative EINs and reporting EINs, and why this distinction matters more than any number series or theory. Number 1, what is an administrative EIN? An administrative EIN exists to identify an entity, not to report activity. An administrative EIN is an EIN that exists for record keeping, identification, internal administration, or anticipated but not realized activity. Entities that commonly hold administrative EINs include estates in settlement, trusts holding assets passively, associations formed but not operating, and fiduciary structures established for continuity. In these cases, the EIN functions as an identifier only. No filings occur because no reportable events have occurred. No third-party reporting has been triggered, and no statutory threshold has been crossed. The EIN remains present but dormant. The key point here is an administrative EIN can exist indefinitely without triggering reporting. Number 2, what converts an EIN into reporting EIN? An EIN does not become a reporting EIN by time or intent. It changes when reportable activity occurs. An EIN becomes a reporting EIN when it is used in connection with a reportable event. Examples include a receipt of taxable income, issuance of information returns, payroll or withholding activity, banking activity that triggers third-party reporting, and agency interaction requiring disclosure. At that point, the EIN is no longer merely an identifier. It becomes a reference point for filings. The critical distinction is this: the EIN does not cause the reporting. Reporting activity activates the EIN. The key point here is reporting follows function, not registration. Number 3, why this distinction is often missed. This distinction is often missed because people are taught to look for a filing rule instead of observing functional behavior. The IRS does not monitor intent. It monitors signals created by use, reporting, and third-party data. Most students are taught to focus on how the EIN was obtained, what number series was issued, what box was checked on the SS4. Very few are taught to focus on how the EIN will be used, whether it will appear on third-party forms, or whether activity will be visible to external systems. Administrative EINs feel inactive because nothing appears to be happening. Reporting EINs feel threatening because something might happen. Most confusion arises when possibility is treated as obligation. As a result, many believe that reporting obligations appear spontaneously when in fact they are activated through use. The key point here is the distinction is missed when silence is treated as a strategy instead of the consequence of inactivity. Number 4, the role of third-party reporting. In many cases, reporting is triggered indirectly through third-party data, not by the entity itself. One of the fastest ways an EIN transitions from administrative to reporting status is through third-party reporting. When an EIN is used by a bank, an employer, a payer, or a government agency, that third party may be required to file reports referencing that EIN. At that moment, the IRS system receives activity data. Presumptions become reinforced, and follow-up correspondence becomes more likely. This process is automated and does not require intent or wrongdoing. The key point here is that third-party reports reinforce existing activity patterns. They do not invent them. Number 5, trusts and the administrative reporting boundary. Trusts sit closer to the administrative reporting boundary because they often hold assets without immediate activity. Trusts are particularly vulnerable to confusion here because they can exist without income. They can receive assets that are not taxable events, and they can operate privately for long periods. However, when a trust receives taxable income, makes reportable distributions, pays individuals in a reportable manner, engages in banking that triggers reporting, then the EIN associated with that trust shifts from administrative to reporting posture. This shift is functional, not theoretical. The key point here is holding assets alone does not create reporting. Transactions do. Number 6, why having an EIN is not the same as using an EIN. Many students confuse possession of an EIN with activation of an EIN. This is incorrect. An EIN can exist without consequence. An EIN may remain unused indefinitely if no reportable activity occurs. And an EIN can be superseded or replaced. The IRS does not monitor EINs for inactivity. It responds to events, not existence. This is why some entities hold EINs for decades without filing anything. The key point here is an EIN only becomes relevant when it is used in commerce, banking, or reporting chains. Number 7, the most common error at this stage. The most common error here is assuming silence must be maintained through form manipulation. At that point, they attempt to reinterpret the SS4, or claim a different intention, or rely on number series arguments. These approaches rarely succeed because the issue is no longer classification, it is documented activity. Literacy before use prevents this problem entirely. The key point is that silence is preserved through lack of activity, not through clever answers. In closing, why function always controls filing. There is no such thing as a safe EIN or a dangerous EIN. There are only EINs that remain administrative and EINs that become reporting references. The difference is not the number, it is the use. Understanding this distinction allows students to interpret IRS correspondence accurately, avoid panic-driven filings, and make informed decisions before engaging in activity, as well as recognize when professional guidance is appropriate. This is not about avoidance, it is about awareness. Filing obligations arise from what an entity does, not what it was named, claimed, or intended to do. Part 3. Trusts, estates, and filing expectations. Chapter 7. The SS4 line-by-line study. Part 1. Identity control and administrative signals. Why the SS4 must be read as a system, not a checklist. By the time the student reaches this chapter, 3 foundational truths should already be clear. Number 1, the SS4 is a classification instrument, not a neutral intake form. Number 2, EIN outcomes are shaped by patterns, not single answers. And number 3, administrative posture is established before any activity occurs. This chapter begins a structured educational review of the SS4 itself, explaining what each section is designed to signal to the system of the Internal Revenue Service and why misunderstandings arise at this stage. This is not a how to fill it out chapter. It is a what it means chapter. Number 1, the function of the opening section. The opening section of the SS4 establishes the identity and continuity. It answers a simple administrative question. What record are we creating and how should it be indexed? At this stage, the IRS is not evaluating tax liability. It is creating a distinct entity record. Errors here are rarely fatal, but misunderstandings here often set the tone for everything that follows. Number 2, legal name of the entity, or line 1. The purpose of the line is to assign a primary identifier to the entity record. What the IRS infers, whether the entity appears personal, commercial, estate-based, or organizational. Whether the name suggests ongoing operations or limited administration. And whether the entity appears distinct from the responsible party. The common misunderstanding is that believing the name itself creates status, protection, or exemption. The educational reality is the name does not control classification, but it contributes to the administrative narrative. Names that imply commercial activity or ongoing enterprise may reinforce presumptions formed elsewhere on the form. Number 3, trade name or doing business as. Line 2 of the SS4 form. The purpose of this line, the associate a public-facing operational name with the entity. To associate a public-facing operational name with the entity. What the IRS infers, whether the entity intends to operate publicly, whether it expects to interact with third parties under a different name, or whether ongoing activity is anticipated. The common misunderstanding is assuming this line is optional and harmless. The educational reality is, while optional, this line signals public engagement. When present, it often reinforces an operational narrative, especially when combined with time-based or employment signals later in the form. Number 4, executor, trustee, or responsible party title, line number 3. The purpose of this line. It is to identify who exercises authority over that entity. What the IRS infers is whether authority is fiduciary or proprietary, whether the entity appears independently administered, or whether control appears centralized in an individual. The common misunderstanding is equating authority with ownership. The educational reality is the SS4 does not recognize philosophical distinctions. It records control relationships. How authority is framed here must align with the entity's actual posture to avoid contradictions later. Number 5. The mailing address, mailing address is line 4 and the physical address is line 5 on the form. The purpose of the lines is to establish the correspondence location. What the IRS infers is very little by themselves. The educational reality is that it addresses addresses are logical, not classificatory. However, they become relevant if later activity contradicts the administrative posture implied elsewhere. For example, correspondence routed through professional firms associated with active compliance. Give me one moment. Okay. Number 6, county and state, line number 6 of the form. The purpose of this line is for geographic indexing. The educational reality is this line has no bearing on tax classification. It exists solely for internal routing and statistical purposes. Number 7, the responsible party identification, lines 7A and 7B. The purpose of the line is to associate the entity with a human point of accountability. What the IRS infers is who can respond to correspondence, who has authority to act on behalf of the entity, and whether the entity appears controlled or independently administered. The common misunderstanding here is believing that listing a person here makes them personally liable or taxable. The educational reality is that these lines establish administrative accountability, not tax attribution. Liability and reporting are determined by activity, not by the presence of a name. Number 8. Why identity sections matter more than they appear. The opening section of the SS4 rarely triggers immediate correspondence, which leads many to underestimate its importance. However, these lines anchor the entity's record, frame how later answers are interpreted, and establish continuity between the entity and its administrator. If later answers contradict the identity narrative formed here, the IRS system responds to the inconsistency, not the intent. Our caveat is identity does not equal classification. Educational clarification. Identity lines establish who and what exists. They do not determine taxability, filing obligations, or jurisdictional posture. Students often overestimate the power of names and titles while underestimating the impact of use and activity. This chapter corrects that imbalance. Our expanded caveat. This caveat exists because identity-based myths cause more SS4 errors than any other single misunderstanding. No responsible party, SSNs, and the foreign jurisdiction myth. One of the most persistent claims circulating among students is that when applying for what is commonly referred to as the 98 EIN, the applicant should not list a responsible party or should avoid providing a social security number, because doing so allegedly places the entity into a foreign jurisdiction or removes it from IRS oversight. This belief is incorrect. Where this belief comes from? This myth typically originates from a misunderstanding of three separate concepts that have been improperly blended together. Number 1, the foreign entities versus domestic entities. 2, responsible party identifications versus tax attribution. And 3, processing outcomes versus legal classification. These concepts operate in different legal contexts and were never intended to be combined. Over time, these concepts were collapsed into a simplified narrative. If you do not list a responsible party or SSN, the EIN becomes foreign or private. This narrative persists because it offers the illusion of control without requiring lawful structure or activity. That conclusion is not supported by law, regulation, or IRS procedure. The IRS terms a foreign entity is one that is organized or operating outside the United States under foreign law. It is not created by omission, silence, or refusal to provide identifying information on an administrative form. What the responsible party section actually does. The responsible party section of the SS4 exists for administrative accountability, not for jurisdictional determination. Its purpose is to identify a human being who can respond to correspondence, someone with authority to act for the entity, and a point of contact if clarification is required. It does not determine whether an entity is foreign or domestic. Assign tax liability automatically, convert fiduciary administration into personal income, or establish ownership. Listing a responsible party does not destroy private posture. Failing to understand what the role signifies is what causes confusion. What determines foreign versus domestic status? An entity is not considered foreign or domestic based on whether an SSN is listed, whether a responsible party is named, or whether a box is left blank. Foreign status is determined by where the entity is created or governed, not by omission on a form. A trust or estate does not become foreign because information is withheld. Jurisdiction is a matter of formation and governing law, not SS4 tactics. Why leaving the responsible party blank is risky. Leaving the responsible party section blank does not create protection. Instead, it often triggers follow-up correspondence, causes processing delays, flags the application for clarification, and creates an incomplete administrative record. The system does not interpret omission as sophistication. It interprets omission as missing information. SSNs, EINs, and misplaced fear. Many students avoid listing an SSN out of fear that it creates personal tax liability, or it collapses the trust separation, or converts fiduciary capacity into ownership. This fear is misplaced. An SSN used for identification on an SS4 does not assign income, it does not create reporting obligations, and it does not negate fiduciary posture. Income attribution occurs through activity and reporting, not identification. Avoidance strategies based on fear rather than understanding often create more scrutiny, not less. Clarifying the 98 EIN misinterpretation. An EIN is not a legal category. It is not a jurisdictional designation, and it is not proof of foreign status. Any outcome associated with a particular EIN prefix reflects processing context, not legal posture. Attempting to engineer jurisdiction by withholding information misunderstands how classification actually works. The critical educational principle here is that jurisdiction is established by law and structure, not by omission. Administrative clarity is safer than administrative ambiguity. Students who attempt to achieve privacy through withholding required information often experienced increased correspondence, requests for clarification, and pressure to correct their filings. This is the opposite of the intended outcome. The alignment with proper fiduciary understanding. Correct private administration emphasizes capacity, sequence, restraint, and accuracy. It does not rely on tricks or omissions, numeric myths, or internet folklore. Understanding the purpose of each SS4 section preserves lawful posture far more effectively than attempting to game the form. Why this caveat matters? This clarification exists because many students unintentionally create incomplete records, invite scrutiny they were trying to avoid, and misinterpret silence as protection. In reality, clarity aligned with structure is what stabilizes an entity record. Omitting a responsible party or identification does not change jurisdiction. It does not create privacy and does not remove reporting obligations if reportable activity later occurs. In closing, why the beginning of the form sets the tone. The first section of the SS4 does not impose obligations, but it does set expectations. It establishes who the entity appears to be, who controls it, and how correspondence will be handled. When these signals align with reality, the entity record remains stable. When they do not, confusion follows. Understanding this section prevents students from assigning meaning where none exists and missing meaning where it does. Chapter 8, the SS4 line-by-line study, Part 2, Entity Type and Classification Signals. Why entity classification is the most consequential section of the SS4. If the SS4 were a courtroom, the entity classification section would be where jurisdiction is quietly assumed. Give me 1 second. I'm getting that tickle in my throat. Most students believe classification happens later, after income, banking, or filings. In reality, classification begins here before any activity occurs. This chapter examines the current SS4 entity type section, explaining what each line is designed to signal, how classifications are inferred, why trusts are routed into subchapter analysis, and where students most often misinterpret meaning. This is the most sensitive portion of the form. This section explains how the IRS decides where to look first, not what must happen next. Line 8A, type of entity. The purpose of this line is to place the entity into an initial statutory category for administrative indexing. On the current SS4, line 8A includes options such as trust, estate, corporation, partnership, or other entity types. What the IRS infers. This section determines which body of law is consulted first if activity later occurs. For example, corporations would be subchapter C or S. Partnerships would be subchapter K, trusts would be subchapter J, and estates is estate administration frameworks. Critical clarification: selection of trust does not mean it's a taxable income, that taxable income exists, or a return is immediately required, or public jurisdiction has been entered. It means if activity arises, analyze under trust law. The key point here is that the entity type identifies the analytical framework, not the existence of income or obligation. Why trust automatically routes to subchapter J review. Subchapter J review is procedural, not presumptive. When trust is selected, the IRS system anticipates possible application of subchapter J, which governs fiduciary income, deductions, distributions, or reporting mechanisms. This routing is analytical, not punitive. As explained in Chapter 1, subchapter J being considered does not mandate filing. It establishes the framework that would apply if qualifying events occur. Most confusion begins when students interpret this routing as an automatic obligation. The key point here is that review does not equal reporting, and consideration does not equal filing. Another caveat: what subchapter J actually is and is not. Subchapter J is not a penalty section, an enforcement trigger, or a filing command. It is the portion of the Internal Revenue Code the IRS consults when analyzing trusts and estates. Just as other subchapters are consulted for corporations, partnerships, or individuals. When an entity is identified as a trust on the SS4, the IRS system automatically routes any future analysis through subchapter J because that is where the governing rules for trusts reside. This routing does not mean that a return is required, or that income exists, or tax liability has arisen, or a Form 1041 must be filed. It means only that if reportable activity later occurs, subchapter J is the statutory framework used to evaluate it. Being considered under subchapter J is the same as the corporation being considered under subchapter C or an individual under subchapter A. It is a lens, not an outcome. Confusion arises when students mistake statutory applicability for statutory obligation. Subchapter J explains how trusts are treated if they have income, distributions, or taxable events. It does not create those events by itself. The key literacy principle is subchapter J tells the IRS where to look, not what must happen. Line 8B. If trust, is it a grantor trust? Grantor trust status describes attribution mechanics, not automatic tax events. The purpose of the line is to determine whether income, if it exists, would be attributed to a grantor rather than taxed at the trust level. What the IRS infers. This line informs attribution logic, not filing inevitability. A grantor trust may exist without income. It may exist without distributions, and it may exist without filing obligations. The grantor designation only matters if taxable income arises. The common misunderstanding is believing that checking grantor trust automatically triggers Form 1041. That belief is incorrect. The key point here is that attribution only matters if reportable income or transactions exist. Number 4, grantor trust status versus filing expectations. It is essential to separate the attribution rules from reporting obligations. Grantor trust rules determine who would report income, not whether income exists. A trust can be a grantor trust, properly classified and fully compliant, and still have no filing obligation if no reportable income or distribution exists. Filing expectations arise from activity and income, not from classification labels alone. Line 9A on the form, the reason for applying. Line 9A provides context for issuance, not a binding declaration of future behavior. The purpose of the line is to identify why the EIN is being requested. On the current SS4, common options include banking purposes, trust administration, estate settlement, and compliance or withholding needs. What the IRS infers is this line strongly influences activity expectations. For example, banking suggests potential third-party reporting. Estate settlement suggests temporary administration. And compliance suggests anticipated reporting activity. This line does not impose obligations, but it shapes the narrative discussed in Chapter 5. The key point here is the reason given does not override later facts. Line 9B, the state where the entity was formed. The purpose of the line is to establish domestic jurisdictional context. Critical clarification is this line, not omissions elsewhere, is what supports domestic versus foreign classification. An entity is not foreign because an SSN is listed, or a responsible party is named, or a box is checked. Foreign status depends on where and how the entity is governed, not SS4 tactics. This information establishes administrative reference, not jurisdictional immunity or exposure. Line 10. The date the business started or trust created. Line 10 records administrative chronology. It does not determine a state origin, jurisdiction, or filing status. The purpose of the line is to establish temporal context. What the IRS infers is whether the entity appears newly formed, long-standing, temporary, or ongoing. For trusts and estate, this date typically corresponds to the date of instrument execution or date of triggering event, for example, a death or settlement initiation. This line does not transform a trust into a business. It provides chronological context only. Educational clarification, the estate origin versus administrative dates. References to a date of birth in private education relate to the concept of estate origin, not to manipulating IRS forms. Line 10 of the SS4 reflects when an entity is considered administratively active or created for record-keeping purposes. Using a particular date does not create foreign status, prevent subchapter J consideration, or eliminate filing requirements if reportable activity later occurs. The key point here is that dates influence expectations. They do not rewrite legal reality. Line 11, closing month of the accounting year. The purpose of the line is to anticipate periodic reporting cycles if reporting becomes required. What the IRS infers whether the entity appears aligned with the calendar year reporting or non-calendar year administration or estate-style accounting. This line alone does not require filings, but it contributes to pattern recognition discussed earlier. This selection affects timing mechanics only if reporting later becomes required. Educational clarification here is selecting an entity type on the SS4 does not mean you have consented to taxation. It also does not mean that you have agreed to file returns or you have waived private administration. It means you have identified the category under which analysis would occur if facts require it. Classification enables review. It does not compel action. Confusing classification with consent leads to unnecessary fear and overcompliance. In closing, why the entity type determines the lens, not the outcome. Entity classification on the SS4 determines which statutory framework is consulted first, how future activity would be analyzed. It does not determine whether income exists or whether filings are required or whether liability has arisen. Those outcomes depend on subsequent facts, not this form. Understanding this distinction allows students to read the SS4 calmly, interpret IRS correspondence accurately, and avoid reacting to assumptions that have not yet been materialized. Applying this literacy prevents premature filings and makes deeper education both safer and more effective. Chapter 9. Informational filings versus income filings. How to read this chapter? This chapter explains how the IRS uses different forms for different purposes. It does not tell you when to file or when not to file. It teaches you how to recognize whether a form records information or declares income. Why not every IRS form means you owe tax? One of the fastest ways students unintentionally create problems is by misreading IRS forms and notices. A common assumption is if the IRS mentions a form, tax must be due. That assumption is incorrect. The Internal Revenue Service administers many forms that are informational, procedural, or record-keeping in nature. These forms exist to collect data, not to assess tax. This chapter explains the critical distinction between informational filings and income filings, and why confusing the two leads to unnecessary filings, unintended admissions, and avoidable exposure. Number 1, what an informational filing is. An informational filing exists to collect or confirm data, not to assess tax. An informational filing is a form submitted to report the existence of an event, identify parties involved, provide data for record matching, and support administrative oversight. Informational filings do not calculate tax, assess liability, declare profit, or admit taxable activity. Their function is descriptive, not determinative. The key point here is that informational filings do not, by themselves, assert that income occurred. Common characteristics of informational filings. Informational filings share identifiable traits that distinguish them from income filings. Informational filings typically do not compute tax due, do not include payment vouchers, and do not determine final liability. Often reference other parties and are used for cross-checking data. They exist to answer the question, did something occur that may need to be understood, not how much tax is owed. Key point here is that these forms ask about activity. They do not declare it. Number 3, what an income filing is. An income filing is a declaration that taxable activity has occurred. An income filing is materially different. Income filings report taxable income, calculate the tax owed, assert that taxable activity occurred, and establish liability for a given period. These filings move beyond description into declaration. Once an income filing is submitted, the IRS treats the reported facts as affirmative statements, subject to verification and enforcement. The key point here is that income filings convert assumptions into recorded facts. Number 4, why this distinction matters for trusts and estates. Trusts and estates are especially vulnerable to confusion because they often receive correspondence before income exists. Trusts and estates encounter both types of filings, which is where confusion often arises. For example, a trust may receive correspondence suggesting a filing framework. An estate may be asked for information during settlement, or an EIN may be referenced without any income activity. In these situations, students often respond by filing income returns prematurely, believing they are required. This reaction can create a reporting history where none was required, introduce facts that did not previously exist, or trigger obligations that were otherwise avoidable. Understanding the difference prevents reactive filings. The key point here is that filing prematurely can create reporting obligations that did not previously exist. Number 5, why IRS correspondence is often informational. Most IRS correspondence is designed to clarify records, not accuse wrongdoing. Much IRS correspondence is system-generated, triggered by an EIN issuance or anticipated activity based on SS4 patterns, third-party data feeds, or timing expectations. These notices frequently ask for clarification, reference potential forms, and provide general information. They do not automatically assert that a filing is due. The IRS is often asking, should something be happening here? Not, you failed to comply. The key point here is a letter requesting information is not the same as a notice of liability. Number 6, the danger of treating informational requests as income obligations. Problems arise when informational prompts are treated as commands. When students respond to informational correspondence by filing income returns just to be safe, they often declare income that did not exist or mischaracterize administrative activity, collapse distinction between entities, or create audit trails unnecessarily. This is one of the most common ways well-intentioned individuals create their own compliance problems. The key point here is that overfiling creates more risk than measured restraint. Number 7, the role of silence versus response. Silence is not a strategy. It is the absence of reportable facts. Another area of confusion is whether silence is appropriate. This book does not advise ignoring lawful obligations. It explains that not every communication asserts one. Appropriate responses depend on whether an obligation actually exists, whether facts support the presumed framework, or whether income or reportable activity occurred. Responding with an income filing when none is required is not compliance, it is over-reporting. The key point here is that responses should be driven by facts, not fear. Why many online explanations get this wrong. Online explanations often collapse all IRS forms into a single category, tax forms. Many online explanations treat all IRS forms as tax returns or assume every notice is an accusation, encourage defensive overfiling, or fail to distinguish data collection from assessment. This chapter exists to correct that error. The key point here is literacy requires distinguishing systems, not memorizing forms. Educational clarification. Once an income filing is submitted, the facts reported are treated as true. The entity is treated as having engaged in taxable activity, and the reporting posture changes permanently for that period. Students should understand that filing is not neutral. Once filed, the IRS treats the reported activity as having occurred unless corrected through formal processes. Accuracy matters more than speed. In closing, why discernment prevents self-created liability? The IRS administers many forms because it administers many systems. Not every form declares tax, assesses liability, or signals wrongdoing. Understanding the difference between informational filings and income filings allows students to read correspondence calmly, avoid unnecessary declarations, preserve correct administrative posture, and seek guidance only when facts require it. Most problems arise not from failure to file, but from filing the wrong thing at the wrong time. Discernment protects structure better than speed. Part 4. Risk literacy and discernment. Chapter 10. Common SS4 mistakes that trigger IRS correspondence. This chapter is not a checklist to avoid the IRS. It explains how administrative inconsistency creates automated follow-ups. Read each section as a pattern recognition exercise, not a rule book. Why most problems begin before any activity occurs. When students receive unexpected correspondence from the Internal Revenue Service, the immediate assumption is often that something went wrong after the EIN was issued. In reality, most correspondence is traceable to preventable missteps at the SS4 stage. Missteps that create inconsistent administrative narratives invites automated follow-ups or signal anticipated activity that never materialized. This chapter identifies the most common errors that lead to unnecessary scrutiny, confusion, or reactive filings. The goal is not blame, but discernment. Treating the SS4 as a simple intake form. The SS4 is simple in appearance, but not simple in consequence. The mistake? Viewing the SS4 as a neutral application rather than a classification instrument. Why it triggers correspondence. When answers are provided casually, the form can describe an entity that appears operational, ongoing, employer-like, or commercially engaged. The IRS system then prepares for activity that never occurs, prompting follow-up. Correct understanding? The SS4 creates an administrative posture, not just a record. The key point is oversimplification leads to inconsistent records, not immediate penalties. Searching for a safe box or dangerous box. Many students approach the SS4 as if it contains hidden traps. The mistake is believing that one checkbox determines outcomes. Why it triggers correspondence? Pattern-based systems respond to combinations. Fixation on a single line often leaves contradictory signals elsewhere on the form. Correct understanding is no single box causes problems. Unexamined patterns do. The key point is that no single box creates protection or exposure in isolation. And number 3, copying another person's SS4. Copying answers imports someone else's assumptions and anticipated activity. The mistake is replicating the SS4 form from a mentor, online source, or historical example. Why it triggers correspondence? Its copied narratives rarely match the student's actual structure, timing, or activity, creating conflicts when reality diverges from the declared posture. The correct understanding is administrative posture cannot be inherited by imitation. The key point is that administrative narratives cannot be borrowed safely. Number 4, using commercial language for non-commercial entities. Language choices shape expectations before any activity occurs. The mistake is describing trusts, estates, or associations with business-style terminology. Why it triggers correspondence? The language implying ongoing operations, revenue, or staffing reinforces presumptions of annual reporting. The correct understanding is words do not create tax, but they shape expectations. The key point here is descriptive accuracy matters more than clever phrasing. Overstating anticipated activity. Anticipated activity is often mistaken for intended activity. The mistake is indicating expected payroll, reporting, or payments just in case. Why it triggers correspondence is the system anticipates compliance activity and checks for it later. The correct understanding is anticipation signals are treated as likely events. The key point is overstatement invites follow-ups that reality does not support. Number 6, misunderstanding responsible party identification. Responsible party identification supports continuity, not attribution of fault. The mistake that believing that listing a responsible party or SSN collapses separation or creates liability. Why it triggers correspondence? Omissions or inconsistencies often lead to clarification requests. The correct understanding is that a responsible party identification establishes administrative accountability, not tax attribution. The key point is confusion here leads to unnecessary concern, not enforcement. Attempting to engineer jurisdiction through omission. Omission is often mistaken for neutrality or privacy. The mistake, withholding information to force a foreign or private classification. Why it triggers correspondence? Incomplete records prompt follow-up and manual review. The correct understanding is that jurisdiction is determined by law and structure, not by omission. And the key point is jurisdiction is determined by facts and activity, not by what is left blank. And number 8, reacting to correspondence with premature filings. Most self-created liability begins with fear-based responses. The mistake is filing income returns in response to informational notices. Why it triggers correspondence? Filing creates facts and establishes a reporting history that may not have been required. Correct understanding is not every notice asserts an obligation. And the key point here is that filing in response to uncertainty often creates the very obligations being feared. And 9, relying on EIN number series for protection. EIN number sequences are administrative artifacts, not legal shields. The mistake is assuming certain prefixes prevent scrutiny or filing. Why it triggers correspondence? It actively contradicts expectations regardless of the number. And the correct understanding is numbers identify records, behavior determines outcome. And the key point here is that protection comes from the structure and conduct, not numbering patterns. The educational clarification here is the IRS system is designed to reconcile information over time. Consistency between what is declared, what occurred, and what is reported is what keeps records stable. Most correspondence arises not from wrongdoing, but from inconsistency. Consistency reduces attention without requiring explanation. In closing, why prevention is easier than correction. Every issue described in this chapter is preventable through literacy before action, discernment over imitation, and understanding over fear. The SS4 does not punish mistakes, it records them. Correcting assumptions before filing is far easier than correcting records afterwards. Literacy reduces risk before strategy is ever required. And Chapter 11, Why Private is Not a Checkbox. This chapter is not about rejecting systems or claiming exemption. It explains how privacy is preserved through conduct, structure, and restraint. Read this chapter as clarification, not instruction. The most misunderstood word in the entire process. Few words are used more casually and misunderstood more deeply than the word private. Students frequently assume that private is a status you select. Private is achieved by wording alone. Private is declared on a form, or private is recognized because it is asserted. None of these assumptions are accurate. This chapter explains why private is not a checkbox, why it cannot be claimed through forms alone, and how misunderstanding this concept leads directly to the errors addressed throughout this volume. What private actually means in administrative reality. In administrative systems, private describes the absence of reportable activity, not a declared identity. In administrative and legal contexts, private does not mean invisible, untouchable, exempt, or outside all systems. Private describes how one acts, not what one declares. Private posture is demonstrated through capacity, as a fiduciary versus the debtor. Structure, separation of roles and entities. Conduct, restraint, consistency, or non-commercial behavior. And sequence, your administration before activity. It is observed, not asserted. The key point here is privacy is inferred from what is not happening, not from what is proclaimed. Why forms do not confer private status. Forms exist to record information, not to grant posture. No IRS form, including the SS4, contains a mechanism to elect private status. Forms collect data, create records, and anticipate activity. They do not adjudicate philosophical or jurisdictional claims. The Internal Revenue Service does not recognize private because it was written, stated, or implied. It recognizes posture after observing behavior over time. The key point here is that completing a form does not change how activity is evaluated. Number 3, the difference between assertion and demonstration. Assertion relies on words. Demonstration relies on consistency. Assertion says, I am private. Demonstration shows no public commerce unless necessary, no inconsistent filings, no contradictory declarations, and no activity that invites public regulation. The system does not respond to language, it responds to patterns of conduct. This is why declarations alone fail, while disciplined administration quietly stabilizes records. The key point here is that administrative systems respond to patterns, not proclamations. Number 4, why misusing the word private creates risk. Overuse of the word private often signals misunderstanding, not protection. Ironically, misuse of the term private often creates the very scrutiny students are trying to avoid. This happens when private is used to justify omission, or private is used to resist basic administration. That private is asserted while public activity occurs, and private is treated as a shield rather than posture. In these situations, inconsistency, not privacy, becomes visible. The key point here is mislabeling posture draws attention rather than deflecting it. And 5, how this concept relates to the SS4. The SS4 does not ask whether an entity is private. It asks what the entity appears designed to do. Private posture is reflected indirectly through administrative-only purpose, limited anticipated activity, absence of public operational signals, and consistency between declaration and conduct. Attempting to force privacy through the SS4 misunderstands the role of the form. The key point here is that attempting to inject private into the SS4 narrative creates inconsistency. Why this volume emphasizes restraint. Restraint is emphasized because it prevents self-generated exposure. This is intentional. True private posture is quiet, consistent, non-reactive, and disciplined. It is not achieved by filing more paperwork, making louder claims, searching for special numbers, or copying other people's forms. The key point here is that most problems arise from saying too much, not too little. The educational clarification here is privacy is not lost because a form exists. Privacy is lost when conduct contradicts claimed posture. The system does not penalize privacy, it responds to activity. Understanding this prevents over-assertion, defensive filing, unnecessary exposures, and self-created contradictions. Privacy collapses when language outruns behavior. The following sections address where misunderstandings about private often escalate into status claims. Status correction claims, sovereignty, narratives, and the SS4. One of the most common sources of confusion for students encountering the SS4 is the belief that status correction must be affirmatively declared to agencies, including the Internal Revenue Service, in order to preserve private standing or avoid jurisdiction. This belief is widespread in sovereignty-adjacent communities, and it requires careful clarification. What status correction is commonly claimed to be? Status correction is often presented as a way to force recognition through language. Within sovereignty or redemption-style communities, status correction is often described as a declaration that one is not a U.S. citizen or a taxpayer, an assertion that one is a living man or woman, a notice rejecting statutory jurisdiction, and a filing that supposedly removes one from all public systems. Students are frequently told that these declarations must be sent to the IRS, included with SS4 applications, asserted to banks and agencies, and repeated across all records. The implication is that status must be announced to be recognized. This implication is incorrect. Why agencies do not recognize status by assertion. Administrative agencies do not determine status based on declarations, affidavits, or notices that assert philosophical or political positions. They determine posture based on capacity in which one acts, type of entity interacting with the system, the nature of the activity, and consistency of conduct over time. An agency does not ask, what status does this person claim? It observes what is occurring and under what framework does it fall. This is why mass mailing status correction notices rarely produces the intended result and often produces scrutiny instead. The key point here is that agencies recognize roles through records and conduct, not declarations. How this misunderstanding interferes with the SS4. The SS4 becomes a focal point for status assertions because it is misunderstood as declarative authority. The SS4 does not ask for political status, citizenship assertions, sovereignty claims, or philosophical positions. It asks for the entity type, administrative purpose, the responsible party, and anticipated activity. When students attempt to assert status correction through attachments, cover letters, modified answers, or omitted information, they misunderstand the function of the form. The SS4 is not a forum for status disputes. It is an administrative classification tool. Attempting to inject sovereignty claims into this process often creates inconsistency, triggers follow-up correspondence, results in manual review, and undermines credibility of the filing. Why people believe status must be asserted everywhere. This belief persists for three primary reasons. 1. Misinterpretation of court cases, where capacity mattered, not declarations. 2. Confusion between private contracts and public administration. What may matter in private agreement does not translate to agencies. And 3. Desire for certainty through declaration. Announcing status feels safer than demonstrating it quietly. Unfortunately, administrative systems do not operate on affirmation. They operate on evidence and activity. The key point here is fear drives over assertion more than necessity. The difference between capacity and status. Capacity describes how one is acting. Status describes how one is classified. A critical distinction is often lost. Status is a legal classification determined by law, and capacity is the role in which one acts. Agencies respond to capacity. For example, acting as a fiduciary versus acting as an individual, or acting on behalf of an entity versus on one's own behalf, and administering versus operating. This is why a trustee acting in fiduciary capacity is treated differently than an individual, or an estate administrator is treated differently than a beneficiary. Capacity is demonstrated through documents and conduct, not declarations. The key point here is that capacity is demonstrated situationally. Status is inferred administratively. Why non-consent and rejection of jurisdiction fail here? Students are often told to include non-consent language without prejudice statements or jurisdictional rejections on or alongside administrative forms. In the context of the SS4, these additions have no legal effect, are not processed as claims, and do not alter classification, and do often create confusion or delays. Jurisdiction is not accepted or rejected by notice. It is invoked by activity. The key point here is that jurisdiction is exercised over activity, not beliefs. The correct education framing. This book does not teach students to assert sovereignty, declare political status, or challenge agency authority through forms. It teaches students to understand that private posture is preserved by correct capacity, structure, and restraint, not by assertion. If status matters in a legal context, it is addressed through proper standing, in the correct forum, at the correct time, and with evidence, not proclamations. The key point here is education replaces assertion. Understanding replaces conflict. For educational clarification, excessive assertion often produces the opposite of privacy. When students declare more than is required, assert positions that are not asked for, or challenge jurisdiction where none is being exercised, they often draw attention to themselves unnecessarily. True private posture is quiet, consistent, and uneventful. Silence is not avoidance, it is alignment. Why understanding private changes everything. Once students understand that private is not a checkbox, fear subsides, overfiling stops, the copy and paste behavior ends, and discernment replaces reaction. This understanding is the foundation for every correct decision that follows. Correct posture reduces risk before strategy is required. And Chapter 12, what this means before you file anything. This chapter does not instruct you to avoid filing indefinitely. It explains how to recognize when filing is appropriate and when it is premature. Read this chapter as orientation, not advice. Why this chapter exists. By the time a reader reaches this chapter, they have been exposed to a critical reality. Most problems associated with EINs, trusts, and IRS correspondence do not arise from misconduct. They arise from misunderstanding sequence, function, and posture. This chapter exists to bring the entire volume together into a single stabilizing perspective, so that nothing is filed reflexively, emotionally, or based on internet folklore. This is the pause point before action. The most important insight of this volume. The most important insight is not technical, it is behavioral. The most important insight conveyed throughout this book is simple. Forms do not create outcomes, conduct does. The SS4 does not make an entity taxable, place someone into public jurisdiction, remove benefits, or confer or revoke status. It merely records how an entity appears designed to function at a moment in time. What happens afterwards depends entirely on how the EIN is used, what activity occurs, whether reporting is triggered, whether consistency is maintained. Understanding this prevents panic and overreaction. The key point is understanding always precedes correct action. Why doing nothing is often the correct first move. Doing nothing here means refraining from premature declarations, not ignoring facts or obligations. One of the hardest lessons for students to accept is that inaction is sometimes the most disciplined response. If no income has occurred, no distributions have been made, no third-party reporting has been triggered, and no agency obligations exist, then filing something to feel compliant often creates the very obligation that did not exist. Restraint is not avoidance, it is correct sequencing. The key point is that inactivity is temporary when facts require action. Reading IRS correspondence without fear. More IRS correspondence is informational and time tolerant. Most IRS correspondence is automated, informational, anticipatory. It often reflects SS4 patterns, timing expectations, and system prompts. Before reacting, the correct questions are: 1. Did a reportable event actually occur? 2. Is this notice informational or declarative? 3. Am I being asked or being assessed? The Internal Revenue Service does not assume wrongdoing by default. Students often assume it for them. Key point here is calm reading prevents self-created liability. Why premature filing is the most common self-inflicted error. Filing creates a record that cannot be undone for that period. Throughout this volume, a consistent theme has emerged. Filing creates facts. Once an income return is filed, activity is declared, a reporting history is established, and consistency is expected going forward. Students who file prematurely often discover they cannot easily undo what they voluntarily declared. The correct question is never, what can I file to make this go away? It is, did something occur that legally requires filing? Key point here is that speed rarely protects, accuracy does. Capacity always matters more than status. Capacity describes how you are acting in a given moment. This book has intentionally avoided teaching students to argue status. Why? Because agencies do not respond to arguments about sovereignty, political identity, or philosophical positioning. They respond to capacity, whether someone is treated as an individual, a fiduciary, a trustee, or an administrator. This all depends on how they act and document, not what they declare. Correct capacity protects far more effectively than loud assertions. The key point here is that capacity is situational and status is inferred. The quiet role of consistency. Consistency stabilizes records without explanation. Administrative systems are designed to reconcile information over time. They are not adversarial by default. When SS4 declarations, subsequent activity, third-party reporting, or any filing that occurs all align, the system remains quiet. When they conflict, correspondence follows. Consistency is not compliance theater, it is stability. The key point is consistency reduces attention naturally. What this volume is and is not. It is educational, preventative, grounding, and corrective. It is not a filing guide, a loophole manual, a sovereignty playbook, or a template collection. Its purpose is to ensure that no form is ever filed blindly again. This volume establishes literacy, not execution. The readiness question every student must answer. Readiness is not urgency, it is clarity. Before filing anything, every student should be able to answer what entity actually exists, what activity has actually occurred, what capacity am I acting in, and what obligation, if any, has been triggered by fact, not fear. If those answers are unclear, filing is premature. The key point here is if uncertainty remains, education should continue before action. Discernment is the first act of private administration. True private administration does not begin with paperwork. It begins with understanding. This volume was written to slow the reader down, not to stop progress, but to prevent irreversible missteps. When discernment comes first, fewer forms are filed, fewer notices are received, fewer corrections are needed, and confidence replaces anxiety. The goal is not to avoid systems. The goal is to engage systems only when facts and function require it. Conclusion: discernment is the first fiduciary skill. This volume was written to address a reality that most students encounter too late. The greatest risk in private administration is not enforcement, it is misunderstanding. Throughout this book, we have established that the SS4 is a classification instrument, not a declaration of status. An EIN is an identifier, not a tax account. Number series do not create jurisdiction or protection. And reporting obligations arise from activity, not paperwork. As well as private is demonstrated through capacity and conduct, not assertion. When these principles are understood, fear subsides and precision replaces reaction. The systems administered by the Internal Revenue Services are not philosophical, they are administrative. They respond to patterns, consistency, and documented fact. Most problems arise when individuals attempt to shortcut that reality through imitation, omission, or over-assertion. This book has deliberately emphasized restraint. Restraint is not avoidance. Restraint is competence. True fiduciary administration begins when a person can read a form without panic, read correspondence without assumption, distinguish inquiry from obligation, and pause before creating facts that cannot be undone. That is discernment, and discernment is the first fiduciary skill. Competence begins when reaction ends. What's next? Next week, we will go over Volume 2, which is Trust Architecture, Strategy, Layering, and Sequence. Volume 1 answered the question, how do administrative systems classify and respond to entities? Volume 2 answers a different question. How should trust actually be designed so that classification, activity, and purpose align? Where Volume 1 focused on literacy, Volume 2 focuses on architecture. What Volume 2 will cover is why one trust does everything structures fail. Administrative versus holding versus an operating trust, estate-based frameworks and sequencing logic, and separation of identity, authority, assets, and activity. Alter ego and unity of interest risk, why layering is strategic, not automatic, and when not to add another trust. Volume 2 does not provide plug-and-play templates either. It teaches how to think structurally so that any trust created is coherent, defensible, and aligned with real-world constraints. Recommended sequence: this volume should be completed before trust drafting, banking decisions, compensation planning, or advanced fiduciary or executor studies. Students who skip architectural understanding almost always return later to fix what's collapsed. And the appendices are designed for educational reference tools. They're not filing aids. This is something that if you wish to have the book, you can provide a donation to our website at www.privatepathhrsolutions.com. And once you provide your $50 donation, you'll receive a copy of every single one of the ebooks. Final note to the reader: this volume was not written to make you faster, it was written to make you accurate. Accuracy protects benefits, accuracy preserves standing, and accuracy preserves self-created exposure. When you are ready, proceed to Volume 2, which we will go over next week on our free live class. And we will see you then. Give me 1 second. I just want to make sure, because those things are going to, yep, we're done. Thank you all for coming. If you were on our live, we thank you. We'll see you next week for Volume 2. Again, if you want a copy of the ebook, you will proceed to our website and provide us with a donation, and you'll get a copy of all the ebooks. If not, come in next week and join us live on YouTube, or you can send us an email to classes@privatepathhrsolutions.com and ask to be added to the class so you can join our Q&A after class. And remember to like, share, and comment if you can. Thanks. Have a good night. Okay. Thank you all.